Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 32 which says that the assessee has to claim the depreciation, and if the assessee does not claim the depreciation in the return of income, then it is the obligation of the department to grant him the depreciation. In the present case, the assessee has forgot or inadvertently missed to claim the depreciation. So the moot question in this case was that, can the assessee claim the depreciation at the time of appellate proceedings? This issue has been taken by the Hyderabad ITAT A bench, and the name of the case is S&P Capital IQ India Private Limited versus Assistant Commissioner of Income Tax. This case has been reported in 109 ITR Tribunal Short Note 56, and the date of the judgment is 26th December 2023. To understand this case, first of all, it is very important to understand the amendment brought by Finance Act 2021, which excludes the goodwill of the business or profession from the block of the intangible assets to claim the depreciation on that goodwill. This amendment brings a clarity also that up to 2021, the goodwill of the business or profession will become the part of the intangible block to claim depreciation. In the present case, there was huge amount of goodwill in the assessment year 18-19, on which the assessee inadvertently failed to claim the depreciation of an amount of rupees 26.04 crores. When the assessment proceedings were going on, the revised return time was over. So the assessee filed the revised computation of income and said that this depreciation of rupees 26.04 crore should be allowed to the assessee according to explanation 5 to section 32 subsection 1. But the learned assessing officer was of the opinion that this depreciation can be claimed by the assessee only through the revised return. The assessee also requested to the DRP, but the DRP also rejected the claim of the assessee of depreciation which was not claimed in the original return. When this matter came to the Honorable ITAT A bench of Hyderabad, first of all, the tribunal said that there is a circular number 14 dated 11th April 1955 which talks about the obligation of the department in unequivocal terms that the department should not get the benefit of ignorance of the assessee. At the same time, that circular reinforces a duty on the assessing officer to assist the assessee in every possible manner to claim any relief which the assessee is entitled to. The tribunal also talks about Article 265 of the Constitution of India, which says that no tax can be levied or collected from the assessee without the authority of the law. Since in the present case, according to explanation 5 to section 32 subsection 1, the assessee was entitled to claim the depreciation even if the assessee has not claimed into the return of income. So there is no bar for the appellate authorities to give the benefit to the assessee of the depreciation even if it has not been claimed by the assessee in the original return or the revised return. Friends, this case is very important because it is not the case of the only depreciation in the present case, but if any other claim which the assessee forgets to claim in the return filed by the assessee, so the assessee can claim that benefit at the time of the appellate authorities also. There is a judgment of Supreme Court in Gadse, India, which talks about on the same lines. But the issue for the assessee is that if the time for filing the revised return is over, then the assessing officer do not have the power to give that benefit. So the assessee has only the option, according to the case of the Supreme Court in Gadse, India, to get it benefit in the CIT appeal or the ITAT or at the higher levels. At the end of this video, once again I am repeating the name of the case. The name of the case is S&P Capital IQ India Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 109 ITR Tribunal Short Notes 56. The matter has been decided by Honorable ITAT Hyderabad A Bench, and the date of the judgment is 26th December 2023. Thank you, friends.